welcome everybody. Thank you for joining us. Thank you for taking the time on a lunchtime. And I'm very happy and excited to be hosting this event as someone who's new to Oregon and still learning myself about the intricacies and history of Oregon specific laws. It's a pleasure to be joined here with Mr. Dan Keppler, who is a longtime practicing attorney in Oregon. He'll give you a bit more information about his background, but he's here to share with us on blue sky, that is to say state laws regarding securities in Oregon and Washington, and advice for aspiring practitioners who may be involved in transactional work. And for some people, you know, securities sounds sort of opaque and scary and something that happens all the way over in Wall Street. But the reality is that it's an area of law that affects people who may not consider themselves securities lawyers. And we're very grateful to have Dan here, who has been sort of beating this drum in the Oregon context for a long time to professionals of all backgrounds to help them gain a greater awareness of the implications of Oregon securities laws for their day-to-day practice. This event is being recorded, and so because of that, we've set it up in a webinar format. I'll ask students as you're going along. Please feel free to ask questions. In fact, I encourage you to ask questions. Please do so in the Q&A. And if you'd like to hold off until the end to have your question asked, that is totally fine. We'll save a little bit of time at the end. If you would like to ask a question, you're welcome to do that. Just indicate so when you write the question down, and I will give you permissions, but just wanted to let you know that this is going to be recorded. So if you don't want to do that, you can just ask the question and I will ask it on your behalf. I will assume, unless you indicate otherwise, that's how you want it to go. So if you do want to ask the question, say, you know, I'd like to ask it or something. But otherwise, you know, please feel free to have any questions and comments as it goes along. And without any further ado, I'll hand it over to Mr. Keppler.
Thank you, Ryan. So for about 20 years, I've represented lawyers and law firms, and also accounting firms and other professionals in Oregon litigation involving the Oregon Securities Law. And I've tried to make it my, I don't want to say crusade, but my approach to try to get the word out on the Oregon Securities Law, which is really one of the most, depending on your perspective, draconian or plaintiff-friendly liability blue sky laws in these 50 states. So I've got a PowerPoint. I'm going to share my screen. Here we are. Okay, here we are. So why do I do this? Why do I go around? Why am I talking to law students, or why do I this is a presentation for transactional lawyers, but it's not very technical. And most transactional lawyers in Oregon don't know much or really anything about about the information in this presentation. So I'm hoping that by showing this to you as a prospective business lawyers, that you'll be able to take this to whatever firms you go to. And as Rohan said, as we go along, I really like this to be interactive, and so I'm gonna encourage you to send questions to him, and he can interrupt me and ask as we go along. So why do I do this? Why do I make these kinds of presentations around the state? There's always a delay with. So as an attorney or as a law firm who handles basic business transactions, you can be liable under the Oregon Securities Law for materially aiding your client's unlawful sale of a security, even if you didn't know about the facts that made the sale unlawful. So the way that I like to unpack all this is to tell a little hypothetical story that is based on a fairly simple real estate transaction. And in fact, it resembles a lot of the cases that I saw after the Great Recession, when real estate prices for especially commercial real estate prices, plummeted. However, any resemblance to actual persons living or dead is purely coincidental. So here's the hypothetical deal. Meet Chad Cheatham. Chad is the developer with the development firm of Cheatham and Howe. It's kind of a regional or local development firm. And Chad has this great idea for a new development in town. It's going to be called Sophomoric Station. It's going to be a mixed-use apartment and retail building near a college campus. He's buying the bare land, and then he's gonna construct the building. And the thing about these kinds of developments is that the way they work is he's going to finance all of this through a bank loan. So he's going to finance the purchase, and then he's going to get a construction loan to finance the building. But banks, they want to make sure they're protected. And what typically happens in a transaction like this is that, Chad Cheatham has to put some money down. He has to show that he's got some equity in this property. And like a lot of developers, Chad Cheatham is cash poor. It doesn't have a lot of, he's got his money tied up in various projects. So what he'd like to do is bring in some, just a small number of investors, people with money who can put money into this thing and own part of it, and give him the equity he needs so that the bank will make him a loan, especially the construction loan for the building. And just to help you understand how these are financed, essentially the bank takes like a mortgage interest in the property and the building. So when it's all built, if something goes wrong, the bank has a mortgage or a trust deed, collateral being the property itself. So Chad Cheatham goes and talks to his longtime lawyer, Drew Dino, his business lawyer, and tells him about the project. And Drew Dino says, Chad, this is a great idea, and I'd love to help you with it. And it sounds like a real promising, development. But I'm just about to retire here. You should just set this up like you say, with investors. And I'm going to refer you to this really sharp new lawyer, Annette Abel, to do the actual transactional work for you on this, and she'll do a great job for you. So Chad goes to Annette Abel, and let's see, let me get my. And she said, "Yeah, I'll draft everything up. You need to go out and find yourself investors." So here are the investors that Chad finds. First, he goes to Hank Howe. Let's just say it's his grandfather, and he said, "Hank, Grandpa, I really need just some money to get me started on this project. So could you just make me, $120,000 loan so that I can just even get started? And I'll give you a promissory note, for the loan. And the firm that we formed will owe you the money." So his grandfather says, "Yeah, sure, I'll do that." Then Hank goes to Landra Rover. Landra Rover is kind of a real estate professional, realtor type person who really can help promote the project. And Chad says, "Landra, why don't you be the marketing director for this project? And you can also be a part owner. If you can kick in $20,000, you can kind of get an interest in the project, sort of through your sweat equity. In other words, by kind of giving her services to the project, she'll pay for her interest. So what she gets is an LLC interest. And what you should know about almost any kind of real estate deal, they're almost always put in limited liability companies that usually both the property, the property and the building are owned by an LLC, and the LLC actually takes out the loan with the bank. So she's going to get.
Sorry, just to interrupt. For the students that haven't taken business organizations yet, right? An LLC is another kind of entity, like a corporation, like a partnership, like a limited partnership that you can set up that as in the name, has limited liability, but can also have a number of members that function sort of like shareholders. They can also function like kind of more of a management role, but basically it's the way, if you get an LLC interest there, it's sort of somewhere between, you know, being a partner or being a shareholder in terms of what you may have benefits for. So that's the way to think about that if you're not already familiar.
Right, and LLC interests are really common. I mean, for these kinds of deals, just because there's some real tax advantages. But it's a little bit like a partnership, and it's a little bit like owning. The LLC interest is called a membership interest, and it's a little bit like owning stock in a corporation. So then Chad Cheatham approaches Claire Coder. Now Claire Coder made a fortune selling her software startup to let's just say Google or somebody, and is just sort of brand new at this investing thing and has all this money, and he convinces Claire Coder to put in $1.2 million of her money. She's heard that you need to invest in real estate because they're not making it anymore. So she's also going to get a significant LLC interest. And the way that these would be like membership units, ownership units in the company. So she's going to put in 1.2 million. Then this is sort of complicated. He approaches another sort of friend of his. Slim Lord is a real estate magnate in town, and he's going to get an interest in the property too, but it's going to be literally an interest in the property. And this is not super relevant for this crowd, but sometimes financing is done by actually giving a person a tenant in common interest in the dirt, in the actual land. Tenant in common interest is like something you may have learned in property law class, but essentially it's joint ownership of the land. And so instead of getting an LLC interest, he's actually going to get joint ownership of the land, and because of that, it has, for somebody who has other property that they're invested in, they can do something called a 1031 exchange for tax purposes, but essentially a like kind exchange. You don't need to know that for this. I use this example because this is sometimes how real estate is financed and how it's attractive to people who already own property. It's not germane to the securities issue here. So what does, whoops. So what does Chad tell these investors, among other things? He tells them, look, I have all the land use approvals I need to get this mixed use apartment building built. And I have, with Landry Rober's help, I'm going to sign a deal with an anchor tenant, Mundo's Coffee. It's a popular national chain of coffee shops, and having them, first of all, they're a good rental risk, and having them as the anchor tenant is going to attract other tenants. So I've signed a deal with Mundo's Coffee. What does Chad forget to mention? Well, it turns out land use approvals in Oregon have to go through a lengthy process, especially if they're challenged, and some of those land use approvals are being appealed by neighbors who don't want this thing built, and that's just a lengthy process. Plus, the Mundo's Coffee lease. Mundo's Coffee is a very sophisticated company, and their lease the lease deal that he has signed with them says that unless he leases up, unless he gets enough commercial tenants in there, let's say at least 60% of the place full, they can pull out of the deal, because they don't want to be the only tenant in this proposed mixed use apartment building retail space. So it's conditional. That's what Chad forgot to mention. Now, what did the lawyers do? So as I mentioned, Drew Dino, the longtime lawyer for Chad, has initial meetings with Chad, then he retires. So he heard about the deal, but he didn't really do anything. What does Annette Abel do? So Chad goes to Annette Abel, and she basically drafts all of the deal documents. She drafts the promissory note with the grandfather, Hank Howe. She drafts some, the LLC agreement. That's like that's basically all LLCs have an operating agreement or an LLC agreement that governs the rights of the owners of the LLC members.
It's like the articles of incorporation. It's like the founding charter of the organization, right? If you're a corporation or an LLC or a partnership, you'll have some sort of founding documents, right?
Yeah, it's also like the bylaws, because some of them are actually pretty detailed. She drafts the LLC agreement. Virtually every LLC has an LLC agreement, although it's not required by the statute. She drafts a tenant in common agreement. This is something you'll not have heard of, but that is how if you want somebody to be a part owner of the property through investing in being in the dirt, owning part of the dirt, you get a tenant in common agreement. And this was actually a popular financing tool right up until the recession 10 years ago. And importantly, she drafts an offering brochure. For a brochure, really, it's like a private placement memorandum is sometimes what they call it, but she drafts some kind of offering brochure that explains to the investors what it is they're investing in, how much, what the project is, how they're going to spend the money, that sort of thing. It's kind of a disclosure document, but it's also, in this case, it's kind of a marketing document. Sometimes they kind of blur the line. And that's actually really important in securities liability. So what happens to Sophomoric Station? And by the way, I called it that because it's near a college campus, and also it means wise fool in Greek. So let's say everything works at first. He actually gets the money from the investors, and he gets a bank loan to buy the property, and also a bank loan for the construction of the property. And that means that the bank has a mortgage type interest in the property. They have the property is collateral for the loan, for those loans, and it gets built. He actually gets his approvals from the land use and from the Oregon land use regulators. So everything's good, and the project is built. But let's suppose this is what happened during the Great Recession and could happen again. A recession hits, and there's a massive decline in real estate prices. And sometimes when that sort of thing happens, the tenants, the proposed tenants, the people who are going to rent the space, especially the commercial tenants, decide they can't do that, or that Chad has to charge them way more than they're willing to pay during a recession. So Mundo's Coffee pulls out of the deal, and because Chad can't rent the spaces for the commercials or the retail spaces for the building, Mundo's pulls out. When Mundo's pulls out, Chad doesn't have enough cash flow. He's not making enough in rent to pay essentially to pay for the mortgage payments on the building. So he defaults. And this is where things are turning to mush. That's what's in the middle there. He defaults on his loan, and essentially what happens when he defaults, the bank exercises its security interest, so they own the building. And typically they do something like a deed in lieu of foreclosure. So instead of foreclosing, he just conveys it to the bank. So now the bank owns the building, and as a result of this, basically all of the bank. The lender on these transactions is superior to all the owners. Essentially, their interest is superior to everybody else's, because they won't lend the money unless that's true. So as a result of that, essentially the LLC that owns the building is worthless. It doesn't own the building anymore, and the investment of the investors is worthless. And so what happens in these cases is the investors will sue. They'll typically sue anybody who has money to pay. So they will probably sue Chad, but they will sue others under the Oregon Securities Law. So that brings us to sort of three key questions for liability under the Oregon Securities Law. First is, was this a sale of a security to these investors? Second, is the seller liable for the unlawful sale? And the seller here is probably the LLC, the company that owned the project, but it could also be Chad Cheatham probably. So is the seller of the securities liable for the unlawful sale? And second, are there non-sellers? That's actually a word used in the Oregon statute. People who weren't the sellers who are liable for participating or materially aiding in the sale. And that's that's where it can get the lawyers involved. So let me unpack each of these questions for you. First of all, what is a security? So Oregon has a laundry list, a very comprehensive definition of what is a security. And by the way, I cite the statute here, but I've given materials to Rohan for him to email to all of you, and everything I say in here,
I just put it in the chat for everybody.
Oh, good, perfect. So all of the citations and all of the cases and everything I mentioned in here is in this outline that's in the materials that covers actually both Oregon and Washington blue sky law or securities law. So there's a definition in the Oregon statute that has a laundry list of things, and it includes what I like to call the usual Wall Street type stuff, what you think of: stocks, bonds, options, notes. And the state law, state securities laws kind of mirror in many ways, for example, the federal securities law, like the 1933 Securities Act, but they have separate definitions and they have separate, they apply separately.
And when you say they apply separately, the federal laws will apply for federal regulations, but these state laws often catch whatever's left over or whatever the federal laws don't preempt, just to be somewhat
Yeah,
reductive.
That's exactly right. And that, in essentially the state law tends to apply to kind of securities in small deals like this that are not securities that are traded on the national exchanges. These are private financings, the kind you really see in Oregon. So in addition to the usual Wall Street stuff, notes are securities. And so remember the promissory note? Notes are securities under the Oregon statute. It's among the laundry list of things that are securities. So so just a promissory note, you loan money to somebody and you give them a promissory note, that can be a security. Now in federal law, the U.S. Supreme Court has carved out what I like to call garden variety notes, like mortgage notes and commercial paper, and said that those are not, commercial bank loans, that those are not securities. We don't really, there is a case in Oregon that Lawn versus Vaseport that says absolutely notes are securities, and considered whether to incorporate the federal approach to those, the federal exceptions. Although it turned out that those just didn't apply to the situation, so it's unclear whether Oregon has really adopted that. But anyway,
my understanding is that with the federal law there, the argument is that they would be securities, except that federal banking law already does a good enough job, so we don't need to regulate them as securities because they're already being regulated as bank products. But I guess at the state level, that argument hasn't been applied, which is maybe why they're still securities, right?
That's right. Well, I think that it basically, the Oregon case didn't really. The Oregon case decided that the securities in question in that case, which I had some involvement in, it didn't actually reach the question of whether the federal exceptions would apply, but because the facts didn't support it, so it didn't get there. But anyway. Basically, private investor loans, however, are going to be securities. So the loan to the grandfather is likely going to be a security under these facts. And I've been involved. There are people that actually make money brokering loans, private loans, in Oregon and elsewhere, and a lot of those private loans are securities. And I have seen securities cases arising, including Lawn versus Vaseport, arising out of those brokered loans. So the main way, though, that something becomes a security in a deal like this is if it's an investment contract. So the Oregon statute, in the laundry list of things that are securities, it includes investment contracts, and investment contracts are sort of like a catch-all, because almost anything involving investors can be an investor contract if it meets this test. The test is it's actually called the Pratt versus cost test. If you've been reading, if you're in a securities class, you might have read the Howey case, the U.S. Supreme Court case. It's based on a modified version of the test used in Howey, which again, you don't need to know that for this purposes. What you need to know is the test, and the test is a 4-part test. Was there an investment of money or something valuable? Was it in a common enterprise? Was there an expectation of profit? And was that profit going to be obtained through the management or control of others? Investment of money, common enterprise, profit, management or control of others. All right, so what are some common investment contracts that meet that fulfill this Pratt test? Limited partnerships. Again, if you haven't had a business organizations class, you may not know about this, but a limited partnership is a kind of partnership where you have general partners and you have a limited partner, and the general partner runs the business and the limited partner just put in money. They're the investors. And virtually all limited partnerships are going to be investment contracts. The statute doesn't list limited partnerships, but they pretty much meet the test. A regular partnership could even meet the test in some circumstances. But the big one is LLC interests. So again, in an LLC, you have members who are the owners of the business, and LLCs sometimes meet the test and sometimes they don't. So here you've got Claire Coder. She became a member of the LLC by putting in 1.2 million of her own dollars. So she invested money in this common enterprise and for profit, and she's not running or managing the business at all. She's just a passive investor. So her investment, her LLC interest is almost certainly a security under the Oregon Securities Law.
Yeah, can you just expound a little bit on that element of management of control of others? We talked about it in securities class. We've got some people here who haven't taken that class, so just what that sort of means in this context. Yeah, thank you.
So here, this is exactly what it means. So what it means here is that she put in 1.2 million of her own money, and she's not going to run the business. The business is going to be run by our good friend Chad Cheatham and his company. And the business is actually going to be the LLC that owns Sophomoric Station, that owns the apartment building. But that's all going to be run and managed by Chad Cheatham. And also it's going to be, remember, he brought in Landra Rover to help with the management, with the running of the business. She actually put in some of her own money, so she's also an investor. But most of the value she gave is going to be what we call sweat equity, meaning is going to work in the business. So Landra Rover might, her interest in the same company, her LLC interest might not be a security because she was helping to management. She wasn't management of others. It was her own work is going to be involved in running the business. So in other words, the word I like to use is passive investor. Claire Coder is a passive investor, whereas Landra Rover is probably not a passive investor. It might be a close question because she put in some of her own money, but passive
you could perhaps design it so that the $20,000 gave her a certain interest and then her work gave her another interest, in which case the 20,000 could be a passive investment or something, right?
Right. Absolutely. There'd be ways to structure this, maybe to help ensure Landra Rover was or was not a passive investor, and therefore her interest was a security. Slim Lord, remember, he got basically an undivided interest in the dirt. He actually owns some of the land that this thing is sitting on, and it turns out that because he did again, I don't want to get into the complications of doing it, but you can actually trade real estate for real estate. Because his interest in that land is actually a security, because it meets the test. It was investment of money or money's worth. It was for profit. It was in a common enterprise. And again, he's not managing or running the company. He's just a passive investor, even though what he put in was he owns the land rather than an LLC interest or stock or anything that we typically think of as securities. So a TIC interest has been held actually by courts to be a security. So what are some common investment contracts? Well, really any interest in a real estate development, I have seen, labeled a security, or I've seen that decided by a court. There's a very popular kind of investment that came out as a result of the new tax law that allows investments in opportunity zones, and there's all kinds of big tax advantages. And most of those are LLC investments or real estate investments. And I expect there were a lot of wealthy people invested in those because of the tax advantages. And those are probably all securities. And I'm just waiting for when things don't go well for those to become litigated in Oregon as securities. But here's my absolute favorite. There's a case in Oregon that says that an undivided ownership interest in a racehorse is a security. It's Marshall versus Harris. It's actually cited in the outline that Rohan circulated. But so basically people got together and bought a racehorse, and somebody was going to manage the racehorse, and the investors were just passive. And so the interest in the racehorse was held under Oregon law, Oregon Supreme Court case from, I want to say it's in the 1960s or 70s, but same law hasn't changed since then. That's a security. Another common area where I'm seeing a lot of securities is in the Oregon cannabis industry. Again, I'm highlighting these are areas where I expect to see securities litigation, because many of there's a lot of private investment going on. So there's a lot of private investment going on in Oregon's legal cannabis industry. Most of these are LLC interests in the business. Sometimes they might be interested in the land. But those can be securities, just like any other kind of investment where you have passive investors. All right, so we now know we have a security. If you're under a security, if it's a security under Oregon law, then there are three forms. And again, I'm simplifying this, but there are three basic categories of liability, where the seller of the security, and that's really the issuer of the security, is liable. One is for a technical violation. One is for what I call classic fraud, and one is for an untrue statement of material fact. And I'm going to go through each of these. Let me talk a little bit. I'm going to start with the technical violation. Hold on. Now let me go back. The way the law works in securities is that all securities essentially have to be registered with the state, unless they're covered by federal law, in which the case they have to be registered with the SEC. Meaning you have to make a bunch of disclosures to the state. It's a long and expensive process. But there are certain what they call exemptions from registration, and a lot of this is a very complicated area where you basically have to be a securities lawyer to understand it. But a lot of these sort of private private equity, private securities deals are exempt from registration. For those who have studied, who are studying securities law, these are under what they call Reg D of the SEC, meaning that they're exempt from registration, and then they have to also qualify for exemption under Oregon law. Although typically, if you qualify under the SEC, you qualify under Oregon, meaning you don't have to spend the money to register and make a lot of disclosures to state regulators. But these technical violation, if the seller sells a security that is either not registered or is not exempt, doesn't qualify for the exemption, the seller is actually liable to the buyer the security, the period, just for a technical breach of the law. Then there's classic securities fraud. I mean, that's just, basically the whole thing is like a Ponzi scheme or a complete scam. And it's a little harder to prove. It's a lot like common law fraud. But and then the number 3 is related but easier to prove, and that's a security that is sold by means of an untrue statement of material fact or a misleading omission. And I have that highlighted here because that's how most of these cases in Oregon are pled. That there was an untrue statement of material fact or a misleading omission in the sale of the security.
And this is analogous to similar federal language, right? You see similar, these are sort of often the kinds of liabilities.
So classic security fraud would be a lot like a 10b-5 claim in federal securities, and untrue statements of material fact are actually like a section, 1933 section 10 violation. But the standards are pretty different. Okay, I'm gonna drill down on untrue statements of material fact, and this standard is really easy for investor plaintiffs to prove in Oregon. So what is a material fact? What is a material fact? I mean, an untrue statement, you know what that means. It just means something is untrue. It doesn't have to be like a bald-faced lie. That would be more like fraud. It doesn't mean that it could be an accident, a negligent misrepresentation. So materiality, material fact is what something is material if a reasonable investor would want to know that fact, which that's not a very hard standard for a plaintiff's attorney to prove, because of course a reasonable investor would want to know it about almost any fact about an investment. Unlike federal law, in federal law you have to prove that the investor relied on the untrue statement, and you have to prove scienter, meaning that the lie was intentional, that there was bad conduct, or you had the person who made the lie intended to deceive somebody or had bad intentions. That's
scienter here meaning just knowledge, right? But being used in a relatively strict sense, that you have to have a fair bit of kind of knowledge and intention, at least in the way the federal laws apply.
Right. So reliance, I mean, this is huge, because if somebody tells you something that's a lie and you don't really, and you rely on it, that's one thing. But if you don't even care, that doesn't matter for purposes of liability under the Oregon Securities Law. If an untrue statement is made, and because there's no scienter, it doesn't have to be an intentional lie. It could be an accidental lie, and that's what makes this law so powerful for investor plaintiffs but difficult for defendants, as you'll see. So Chad's statement about the land use approval, saying he had all the land use approvals, is probably an untrue statement. He really didn't have the approvals. They weren't finalized. They were being appealed. That's an untrue statement of material fact, and that would probably be enough to bring a case under the Oregon Securities Law. I have seen many cases where the offering circular or the offering brochure misstated some fact about the company's founders, or didn't, and they've used that as a basis for liability, as an untrue statement. So remember, it's untrue statements of material fact or misleading omissions. Again, omissions are meaning you didn't are kind of complicated, but here's how the statute reads. It reads something like: a security is sold by means of an omission to state a material fact necessary to make the statements not misleading under the circumstances. And what does that mean? What it means is really like a half truth. So a misleading omission is a half truth, meaning you. And here, the example I used here is Chad's statement about the deal with Mundo's Coffee. He said, I made a deal with, I signed an agreement Mundo's Coffee to be the anchor tenant. Well, that was true, but what he didn't disclose was that there was an unfulfilled condition that Mundo's Coffee could pull out of the deal if the apartment or if the retail spaces weren't 60% rented, say. And so his statement was true, but it was only a half truth because it was misleading under the circumstances. And that's what an omission is. And again, omissions are frequently alleged. Misleading omissions are frequently alleged in these securities cases that I see, because it's not that hard to prove that somebody who was trying to sell a security made engaged in some sort of puffery or made a half-truth statement about the situation.
This is the truth, the whole truth, and nothing but the truth, right? That's that part of that whole thing.
That's right. Hold on. All right. So again, we're talking about the seller liability and what the seller of securities said. So what are the damages for seller liability? The damages are sort of an all or nothing thing. You don't have, it's not like in torts or where you have to prove like loss causation, or it's not like in contracts where you prove, benefit of the bargain. Essentially, you get your money back. You get the amount of whatever money they put into the investment, they get their money back. It's a lot like rescission in contracts. It's called a rescissionary remedy, but it's completely statutory. So you don't have to prove the things that you would have to prove to rescind a contract. So you get the amount of the investment minus any gain. So suppose they had gotten some money on this investment, that's deducted from their investment losses. It's their net investment losses. Plus they get interest at the 9% Oregon statutory rate or the face value of the investment. So suppose the promissory note that Chad Cheatham signed with his grandfather had a face rate of 10%. He would get 10% instead of 9%. So you get minimally 9%, which is a huge interest rate under today's interest rates, plus attorney fees in favor of the plaintiff's attorney. It's a discretionary fee award, like a lot of statutory claims. So that's seller liability. Now I'm going to talk about non-seller liability, and I use that term literally as in the statute. And this is the liability of people who had something to do with the transaction but weren't the seller. So what the statute says is that a non-seller can be liable in several ways to the same extent as the seller, and that it's joint and several liability, meaning you can sue. You may have learned about this in torts. You can sue the non-seller for the full amount of your damages, which is the full amount of the investment loss, and you don't have to sue. You don't even have to sue the seller. You can sue any of these people and collect your judgment from any one of them. That's what it means. And again, I've got the bomb picture, because this is what is very unusual. All of this about non-seller liability is incredibly unusual in Oregon. I'm only aware of 2 other states that have anything similar. So there's 3 kinds of non-seller liability, and the first 2 are actually common in most states' laws. Control person liability, meaning the person who controlled the company, and number 2, people like directors, officers, managers, who really are also control people, but essentially people who are in charge of the business, who ran the business, are going to be liable. And that's pretty common among all state blue sky laws. But what's really unusual in Oregon is that the statute says that any person who participates or materially aids in the sale of the securities is liable to the same extent of the seller. Participates or materially aids. And this is where I see professionals who were involved in the transaction being sued and facing liability. So let me drill down on that one. Oops. So participates or materially aids in the sale. What does that mean? So it turns out that there is pretty old case law in Oregon, Prince versus Bryden. It's cited in the handout. saying that a lawyer who prepares documents that supports the sale of security, and especially those documents like the offering circular, private placement memo, disclosures to investors, those types of documents materially aid the sale, and so the lawyer can be liable for materially aiding the sale. And here's the other part of the Prince versus Bryden case. And this case is a case from I want to say I should know this off the top of my head, but I want to say it's in the late 80s. So this is like not new law at all. It doesn't
88.
require knowledge. Yeah. It's Justice Lindy who's kind of he's kind of a well-known Oregon Supreme Court justice, wrote this opinion. But the thing that he says in Prince versus Bryden is that knowledge is that the person who materially aids the sale, like the lawyer, doesn't have to have knowledge of the seller's bad conduct, that the seller's conduct that made the sale unlawful. So all the lawyer did what he was supposed to do, and by virtue of him having just done the work, even if the lawyer wasn't negligent or did a good job, that's enough for the lawyer to be liable. Now, the lawyer or any other person who participated in material aids the sale. Now, there's something called the due diligence affirmative defense. It's actually not called that in the statute, but there's a similar defense under federal law. And the person who participated or materially aided the sale of securities is not liable if the non-seller did not know, and in the exercise of reasonable care could not have known of the existence of facts on which liability is based. So in other words, it shifts the burden of proof from the investor to the non-seller, third party person, to prove that they could not have known of the unlawfulness of the sale, or they could not have known about the facts that made the sale unlawful. And it turns out that's a really, really difficult burden to prove. As you can see, you're kind of proving a negative. You're asking somebody to show they could not have known certain facts. And, it's pretty easy to see where a lawyer who is helping a client is going to have a relationship with the client and, could have simply asked the client about what they were telling investors or what was going on with the sale. So I have never actually seen this affirmative defense ever proven in an Oregon court. So going back to our hypothetical, who materially aided the sale of securities? Well, Drew Dino just, heard about the deal and retired, but Annette Abel, did everything. She prepared the offering circular. She prepared the promissory note. She set up the LLC. She did the transaction with the property, and probably, most importantly, the offering circular is going to make her liable under the Prince versus Bryden case. So what can you do? Well, unfortunately, there are no safe harbors under the Oregon Securities Law, and so everything I say about what you can do to avoid liability are just kind of my facts I wish that I had when I represented a client. But there are no safe harbors. The first thing you can do is understand your risk. And, this is why I give this presentation to lawyers and accountants. And by understanding your risk, you can maybe spot the issues ahead of time. Number two, choose your clients carefully. I mean, this is always difficult when you're a lawyer and you're starting out, you want to get new clients, but, you really want to choose people who are going to be trustworthy and transparent with investors and not oversell their projects. And I also see a lot of cases where people seek investments from vulnerable people, elderly people, or they seek investments for people in their social or church or religious organization, people with whom they have a trust relationship. And those are always red flags when you're talking about investments. And clients should have a solid business plan and not, they should have money, money controls. Choose your deals carefully. Don't get involved in deals with passive investors in which the deal is probably too good to be true, or is, you know, and unsophisticated investors need to be really independently represented. Choose your partners and associates carefully. I have seen a number of cases in law firms where an associate or a junior level partner was actually, involved with a client who was selling security, who was doing some kind of investment deal, and really was not consulting with more senior lawyers about what was going on, and as a result, kind of, put the whole firm at risk. So it's important to mind the company you keep. So that's all I have. I'm happy to answer any questions, as long as, and even to stay and talk more if Rohan has time. I hope that as law students, if you take that you'll take this information with you to firms that you join, especially in Oregon or even in Washington, when they do, a lot of Washington firms do Oregon deals. And, I think what you're going to find if you raise this is that senior lawyers, business lawyers, are just not aware of this type of liability for participating or materially aiding in the sale of securities. And so I sort of make it my mission to try to increase the knowledge level, because a lot of the lawyers in law firms I've represented had no idea that often that they were even involved in a securities transaction. They thought they were just involved in a real estate transaction or something else. And even then they really didn't understand the liability risk. So anything?
Yeah, thank you. Sorry, are you finished? Apologies.
Yeah.
Thank you so much. Yeah, thank you so much for that. I wanted to start off with a question, but please, any students who've got any questions, anything general or related specifically to parts of the presentation, please feel free to ask them in the Q&A, or just put your hand up and I can unmute you. But I'm going to kick it off. Just have, I don't want to go too much over time, but I often say to our students that they're going to be the first generation coming in after the pandemic. They're going to be sort of native post-pandemic lawyers in a way that a lot of us are going to be working out what that means. But that it's often important as a young lawyer to try to work out what your kind of value add is going to be relative to people with more experience. And one way to do that is to find areas that people haven't been focusing on and make those your areas. So I guess one question to you, Dan, is, say there is a young attorney who listens to your presentation, takes it all on board, and then does go into a firm and sees work where this might be an issue. How do you think would be the best way for a young attorney to bring some of these up in the most useful, constructive way that doesn't sort of sound like they're coming in and trying to tell experienced lawyers how to suck eggs, but also to kind of add value in an early part of their career, or perhaps make this one of the areas that they are specializing in or have something to offer?
Yeah, let me just say that I had never taken a securities class in law school. So I learned all of this because I had a practice. I was at a firm that represented lawyers and accountants who were sued for like legal malpractice. But these cases started creeping in, and so I just started studying. There's not that much case law in Oregon on this, and practically all of it's in the outline that was distributed. But if you read Prince versus Bryden and show that to anybody, it's like a short opinion that it's not hard to understand, and you kind of when I have to show it to lawyers, their mouths kind of just drop open and said, I can't believe that. So I think I think what you do is you show them the statute, you show them you learn this stuff, and I think it is really good information to bring to to a business firm, even if most business practitioners don't really do anything with securities, really don't handle, offerings or whatever. And when you have a deal like this, where there's passive investors, that's when, you want to bring in lawyers who actually have securities expertise to help structure the transaction and maybe avoid some of the risks.
I have one other question then, which is, you mentioned obviously this was a real estate example, and you mentioned other possible examples, including sort of marijuana businesses and things. I have often been sort of harping about the importance of understanding kind of the evolving technological space, because a lot of the same kind of securities issues come up a lot with all these emerging digital assets, whether they're coins or tokens or cryptocurrency or NFTs or whatever else it is. But I was also thinking, as you were talking, maybe even things like intellectual property. You could have joint interests in intellectual property or something that could constitute a security, depending on how it was structured. So are there any other kind of obvious areas of law that we haven't already talked about that you could think of that people sort of might find themselves stumbling into securities related issues?
I mean, I think for these kinds of, first of all, any kind of initial coin offering, or those are all, or any kind of, current, whatever, cryptocurrency, those are all, I think the SEC has pretty much decided that those are all securities. And for the most part, a lot of those are regulated by the SEC because they're kind of, because of the way the offering is structured. But yeah, that's definitely an area. People are always coming up with new and types of investments, and really, if it meets the 4-part test, it's a security. And that's kind of the catch-all. The catch-all being investment contract. If something is an investment contract under that 4-part test, it's going to be a security. And an awful lot of things are securities. Actually, one of the most prominent plaintiffs lawyers who's often my opponent in these cases has a painting in his office that he actually established in a case was a security because there was like investors in this painting or something like that.
I'm going to need to follow up with you on that, because a colleague of mine, a law professor at Kentucky named Brian Fry, wrote an article where he submitted a no action letter request to the SEC that he said was a work of performance art that in itself was a security, and asked them to declare that it wasn't. But this idea that art could be itself a security, or anything that we could be jointly investing in could be a security, much beyond what we normally think of the world of Wall Street, I think is an important thing for people who might be practicing in areas maybe far away from finance, but still implicating these laws.
Yeah, that's exactly right. I mean, a lot of times people, I'm trying to think of some of the securities I've seen people selling. Well, a lot of times people are selling these kind of what they call hard money loans, private loans. Those can be securities. I've seen securities where people were selling interest in mortgages. They were sort of, they were sort of mortgage-backed securities, but on a really small scale, like locally, and they were taking
like one mortgage
money,
or something like that.
Well, yeah, or just a small number of trust deeds, and
one student is asking about intellectual property here. I mean, just my thinking there would be, for example, someone could get a patent and have a group of people that were investing in the patent or something. Is there any sort of things around that you could imagine? Yeah.
Oh, easily. So if anytime somebody's going to go out and get passive investors, really to help pay for the development of the patent or whatever, entrepreneurial types who are going out, it happens all the time that small business people go out, they're starting a business, and they go and get money from their friends and family, and even if they don't actually issue stock, and it's just kind of, it's a loan, all of those things implicate the securities law. Those are all, those are passive investors who are not running the business, and it's just all the time in Oregon there's these kinds of small entrepreneurial situations which can implicate this law. And as long as nobody loses money and it's all on the up and up, these cases never get filed. It's just when things go poorly that they get filed.
And one last question, and then we'll let you go. And thank you for everyone who's been staying around. I know you're also on the Oregon bar section for securities law. So I was just wondering, if you had any suggestions or thoughts or sort of invitations for students who may be interested in this area or related issues, how they could get more involved in the Oregon legal scene.
Yeah. Actually, if you're interested in securities law, almost all the lawyers that practice in this area are members of the Oregon State Bar Securities Law section, and we actually try. We have, well, pre-COVID, we pretty much had a monthly luncheon meeting that we would have with some kind of a presentation. And I've given some version of this presentation 2 or 3 times at these. And we've been doing some things with Zoom, but yeah, I mean, people, I think
and students are invited to attend.
Yeah, I mean, I think people would be welcome to contact me, and we could. I think people would like to. It might be a way to meet lawyers who are practicing in this area. It's there's 2 types of securities lawyers. There's really people who do transactions, and then there's people like me who do litigation. And this is like a place where we all sort of meet. And sometimes the litigation lawyers are suing the transactional lawyers, but it's a really, because it's a small number, it's not that many, it's mostly lawyers in Portland that do this kind of work. So it's a pretty small bar, so to speak. And I'm sure we could, if people wanted to contact me, I guess I'm the immediate past chair is my official position with the section, but I'm sure that we could find a way to invite you to these things. I mean, the Oregon State Bar's website has information about the various sections and what they do, which when you become lawyers, you'll really have total access to that. But I think even the kind of the public parts of that. But if students want to contact me, that would be fine. And maybe Rohan, with you, we will, we can kind of continue this and have. I can keep you in the loop on things that are going on in the section or whatever, and maybe even have some ways for students to get involved and to meet lawyers who are practicing in this area.
Fantastic. Well, thank you very much. I really appreciate you taking the time, and on behalf of everyone, thank you for all of your insights. If anybody wants to follow up, please feel free to reach out to me and I'll put you in touch with Mr. Keppler. But looking forward to having you hopefully join us again in the future, and hopefully helping some of our clients in Oregon avoid some of these pitfalls. So thank you very much.
All right. Thank you. It was fun.